Good morning, everybody. I am going to slow roll my comments until everybody makes it in from the waiting room. Oh, look, we're all there. Awesome. Well, thank you all so much for joining us today. We are happy to have you here as we are every week. And I'm going to start like I do every week with some Zoom housekeeping tips. The first request is that you please stay muted unless you need to unmute yourself to ask a question. It just cuts down on background noise and makes it easier for everybody to hear. If you're wondering where your mute button is, it's wherever your Zoom toolbar is, which is usually at the bottom of your screen. That probably varies by device. That's where you'll find the mute and unmute buttons, as well as the start and stop video buttons. That is also where you will find the chat button, which might be flashing right now because I put a message into the chat reminding everybody that if we don't get to your questions today, we can cover them next week. And if we don't get to your question today, or if you think of something new for us to talk about for next week's Q&A, a reminder that the cutoff time to submit questions is Monday afternoon at 4 p.m. So if we receive your questions by that time, we do our best to research and be prepared to answer them at that week's Q&A. If your questions come in later that evening or sometime on Tuesday, sometimes we have time to get to them and add them to the list, and sometimes we don't, so keep that in mind. The chat is the best place for you to ask questions today. You can also ask for us to clarify something that we've said in our answers or comments on certain topics. We do ask people not to use it like the CAI message boards, where sometimes people kind of get into arguments about things or whatever. And I think y'all are pretty well behaved and haven't done that in a long while. So this is probably an unnecessary reminder. As is, well, maybe this one's a little more necessary, which is that we are here to give general legal information and not legal advice. So if you send us really specific questions that require us to interpret your governing documents, or that require you to give us a whole bunch of facts, if you find yourself typing multiple paragraphs in your question to us, it is very likely too specific for us to answer in the context of this Q&A. And also, if we tried to answer your question, we probably, or anyways, there's a chance that we would get it wrong, because we can't speak to the specifics of a situation without both reviewing your governing documents and understanding which statute your community is subject to. So keep that in mind. We're not here to give legal advice. And so if somebody sends you one of our recordings and says, Valerie said X or Lisa said Y, and you have to do this thing or you can't do that thing, you can just ignore them, because this is not legal advice. And if you find that you're in a situation where having legal advice would be helpful to your community, please consult with your association attorney. If you don't have one of those yet, get one now before you need one, so that you're not scrambling to find that relationship when you are in a crisis where you really need an attorney right now. So moving on to our other weekly reminders, the CTA is still being challenged on a number of different fronts. And so we are still telling clients that it's a reasonable approach to wait on whether and how to take steps towards compliance until a little bit later in the year. You know, we're only 5 months into 2024, and right now the effective date is January of 2025. But there's a court case that's challenging the constitutionality of the CTA. And there are also efforts to, at a minimum, delay the date of compliance or required compliance to the CTA at the national level. So we'll keep you posted as we hear more about the outcome of both of those things. Also, a reminder that we've been giving you the last few weeks is that a number of revisions to WUCIOA are going to take effect on June 6th of this year, which is next month, of course, only in 2-3 weeks from now. I think a lot of people really focused on the WUCIOA for all part of that bill, to the exclusion of the changes that were made to WUCIOA as it exists now. So if you are a WUCIOA community, you should just be aware of the fact that some of those changes are coming down the pike. The revisions are not currently available on the legislative website. So if you type in, RCW 649525 or whatever, and it's a section that's been revised, you won't see the revision on the legislative website, but you will see a note somewhere on the page for that chapter or that subchapter that says, note changes in 2024, and that links you to the bill where you can go look at those changes. Another reminder, or I guess announcement, is that we are not going to have a Q&A on Wednesday, June 19th. So please mark your calendars. Our office is actually going to be closed, as are the courts. It's a state holiday. So we will not be here on Wednesday, June 19th. So please plan for that. We will also send an email reminder in the week prior to that normal Q&A date so that you guys are reminded that we won't be here that day. And the last thing that I wanted to share with you is that for those who are members of WSCAI, which if you don't know what the heck that is, it's the Washington State Community Associations Institute. They have a free webinar coming up on June 20th. It's a DEIB, which is Diversity, Equity, Inclusion, and Belonging webinar. I just put a link for the event in the chat, which is at the WSCAI website. And if you're free that day and you want to join that webinar, we would love to have you. I serve on the DEIB committee for WSCAI, and we're really excited. This is our first year as an official committee, and we're excited about the speaker that we have for that webinar, and I hope that some of you will join us. So without further ado, unless you have anything to add, Lisa, I'm going to jump into the questions.
Nope, go right ahead.
Okay. All right, here is our first question. What is attorney-client privilege, and what types of communications does it apply to? If a board wants to explain to owners that an action was based on the attorney's written opinion, does that negate the privilege of the entire written document containing the opinion? So I'm going to give a short answer to that last question first, which is that mentioning that a decision was made upon the advice of an attorney does not waive the privilege. But disclosing the actual communication where that advice was given does waive the privilege. So whether it's an email or a memo or a letter, attorney-client privilege protects confidential communications between a lawyer and their client that seeks or that relates to the client seeking of legal advice on a particular matter. And in the condo or community association world, the association is our client. When we represent an entity, it's the association that's our client. But the board of directors is the group that is charged with governing the association. And because I can't have an actual, conversation with an inanimate entity like an association, it's the board that has the benefit of the attorney-client privilege, right? So the protection extends to any information that is exchanged during those privileged communications. And it includes both oral or verbal communications as well as written communications. So this might be, for example, a really great example of the kind of thing that does belong in executive session. I know you guys hear me beat the drum often about how a lot of associations include too much stuff that doesn't belong there in executive session. But if you're consulting with your attorney on litigation or other disputes, anything that where the attorney is going to be giving the board legal advice, that's the perfect kind of thing that would belong in an executive session. I would like to also say that although emails between the attorney and the board are privileged or protected by that attorney-client privilege, copying an attorney on an email that's otherwise not privileged does not magically make that email privileged. We have a lot of people who have the misconception that just copying the attorney on the email automatically makes that communication privileged, and that is not the case. So that is something to keep in mind. The privilege always belongs to the client, and it's always up to the client whether to waive the privilege or not. And so in this situation, like I said, the association is the client, but it's the board that gets to decide whether to waive the privilege. I will also offer some clarification, because one of the things that we talk about is copying third parties on privileged communications is one way that you waive the privilege, whether you intended to or not. And so if you copy or even BCC someone who is not on the board, because I don't know why you would do that, but maybe you copy your insurance agent because it has something to do with insurance related stuff that's also legal in nature. That is a situation where you are potentially inadvertently waiving the privilege. On the other hand, a lot of people will try to argue, well, the manager was copied and so that's waived. No, that's not the case. The manager is acting as an agent of the association, and that agency relationship means that when they're involved in those attorney-client privileged communications, that does not waive the privilege. So going back to the other part of the question, simply mentioning that a board decision was based on the legal opinion of counsel doesn't waive the privilege. Of course, we can't comment on any particular situation that your specific community has been through because we also don't know exactly how you're communicating it. But I think part of what's important to note here is that not all attorney opinions have black and white clear answers. An attorney opinion letter will often discuss that there are several possible options available to the board, many of which can be supported legally, even if they're different outcomes. And we'll discuss the pros and cons of those different things. And then usually what will happen is the board will make a decision to choose one of those options. And releasing the communication that we've had that discusses all the options and tells you how to defend all of those options and support all of those options. If you release that to your ownership, one of the ways that Ken actually is the one who mentioned this, and I thought it was a great way to think about it, is that you're giving your owners the ammunition that they need to attack the choice that you made as a board, right? And so once the board chooses an option, one way that you can share with your ownership the basis for the board's decision is to ask the attorney to prepare an opinion that's intended to be shared with the ownership, with the rationale that explains the rationale behind the board's decision. So all of that is just to say, I mean, if I'm going to boil it down to just a couple of short bullet points, copying the attorney on other emails does not automatically make those emails privileged. Telling your owners that you made a decision because the attorney advised you to make that decision does not waive the privilege, but sharing any of those communications outside of the board and maybe the manager does waive the privilege. If you're considering releasing an attorney-client privileged email or memo or letter to your ownership or to anybody else, please, please, please ask your lawyer before you do it. One of the most difficult things for us to deal with is when clients forward our communications outside of the board without realizing that what they're doing is waiving the privilege. And it can kind of create a little bit of a storm that is, or a mess that's hard to clean up after the fact. So if we know that you're looking to release that information in advance, we can help you tailor how it is communicated to your ownership in a way that's less likely to lead to that kind of mess, I guess. There's a follow-up question in the chat that says, directors can consult with others that are not on the board. In that case, can privilege be extended and would that require an agreement? My default answer to that question is no. And my second default answer to that question is it depends, and you need to consult with your attorney before you disclose privileged communications to that person that you are consulting or that company with which you're consulting. And then there's another follow-up question that says, what if you want to quote part of the attorney opinion? That I think would also waive the privilege, or at least risks waiving the privilege. And again, I would recommend that you check with the association attorney before you make that decision. And I'm not even saying that you're checking with the attorney because you're asking for permission and they're going to be like, no, you can't release that. Again, the privilege belongs to the client. It is the client's decision. It's the board's decision whether to waive that privilege and release any part of that communication outside of the board, right? It's more about consulting with the attorney so that you can understand the ramifications, the potential ramifications of that decision, so that the board then is making an informed choice about whether to share that communication and waive the privilege. Lisa, did you have anything you wanted to add before we move on to the next question?
I don't think so. I was just going to, on your last point, just that sometimes waiving the privilege, it isn't the worst possible outcome, but that's something you should take and make an informed decision about. Okay, next question. Do the RCWs require written notification from a homeowner to allow emails about their association from the board or management? Can a homeowner email be replied to if that notification is required? The question is a little bit confusing the way it's written, but I think what the person is asking is if a homeowner emails you and they haven't opted into electronic communication, can you respond if you're the board or the manager? And the short answer is yes, you can certainly respond. The statutes that apply to associations in Washington require that if you are sending a notice to a homeowner by electronic communication that's official to the association, you need to have the owner, had the owner opt in to electronic communication. And we've discussed that pretty much a lot at length over the past couple of years. Something that you need to have in writing, something can be reduced to a writing in your records that says that the homeowner has in fact said, yes, please send me stuff by email, basically. But to answer your question, if a homeowner emails you as the manager or the board or whomever the person representing the association is and asks a question, you can certainly respond to that question via email. Email is often the best communication tool we have. And if someone is reaching out to you, then there's no harm in responding to that person. But if you are sending them something official, like a notice of lien, a notice of a fine, some kind of budget notice, anything like that, you need to make sure that you have authorization and an opt-in in your records that says that that person that you can communicate with that person that way. So again, yeah, even if they just email you first, that isn't the opt-in. The opt-in is them actually affirmatively stating that they agree to accept communication that way. I think that have noted in the notes that that's a two-way street. So if the board has not agreed to accept communication via email, then a homeowner emailing you isn't. If you have a set of rules or set of procedures on how you want people to communicate with you, and they send you an email, that doesn't waive that opt-in by the board. Just the same way that a homeowner wouldn't have waived, but just by emailing you. I think that answers the question. But Valerie, anything I missed on that one?
No, I think that, well, I will offer that it's instructive to read the text of the statute where it talks about electronic notice. And it says notice to unit owners or board members by electronic transmission is effective only upon the unit owners and board members who have consented in the form of a record to receive electronically transmitted notices and have designated in the consent the address, location, or system to which such notices may be electronically transmitted. In other words, the opt-in, as Lisa mentioned, has to be reducible to a record, and it has to contain the owner's instruction on how to send them electronic notices. And then the other thing I'll remind us all about is the statute also says that if you get 2 bounce backs, let's say an owner opts in and says, please send all association notices to johnsmith@gmail.com. And then you're sending electronic notices to that email address. And then you get a bounce back in response to one of the notices. If that happens twice in a row, you have to treat that like they have opted out of electronic notice and revert back to sending them required notices by mail. And then again, just to recap, but if an owner emails you about something, the light bulb's out in the stairwell, there was a broken planter in the whatever cabana, you can write back via email. That's not an official notice that's required by the documents. And the other thing is, even if you do send something to someone by email that they haven't opted in to receiving electronic notice, if it's a required notice under the documents or the statutes, you can also just print a copy of it and mail it to them. And then you have satisfied the notice requirements under the statute. All right, I'm going to move on to the next question. Please explain this, especially concerning 525. So the person's asking about RCW 6490-525, which is the budget ratification provision of WUCIOA. It is my understanding from 085 of this new RCW that it still needs adoption by the HOA prior to 2028. Does that include 525 or is that an exception? Our HOA exceeded our 5% cap citing this bill, and we did not adopt this to our CC&Rs and bylaws. So I think the question here is, does WUCIOA, as it currently exists, truly override any cap on increases in assessments that are contained in your CC&Rs if you are an HOA community governed by the HOA Act? And the question is, does 525 really apply to everybody right now, or do we have to vote to adopt it in order for it to apply to us? And the short answer to that question is 525 applies to everybody. So the part that requires you to follow a certain process to ratify your budget, that applies to every community in Washington state and has applied to every community in Washington state since 2018 when WUCIOA was enacted. And that doesn't matter whether you voted to adopt it or not. The legislature decided as a matter of public policy that having a transparent budget ratification process where owners were given certain pieces of information before ratifying the budget was in the best interest of community associations and the people who live in them as a whole. And so the budget ratification provision of WUCIOA applies to everybody. Beyond that, for communities that are governed by the HOA Act, which is RCW 6438, caps on assessment increases that are in your CC&Rs were invalidated by RCW 6490-080 subsection 2. And that part of that statute reads as follows: to protect the public interest, RCW 6490-095 and 525 supersede existing provisions of the governing documents of all plat communities and miscellaneous communities previously subject to the HOA Act. I'm paraphrasing that last bit there. So the supersede language means, so what it says is it supersedes existing provisions of your governing documents. That means the statute trumps what your documents say. And I can tell you that the legislative intent here was really clear, because the legislature recognized that a lot of these HOA CC&Rs had caps on increases without any sort of provision for like inflation or other cost of doing business increases. And what this created a tension between the association's obligation to pay for things like insurance, common element maintenance, etc., and their inability to raise the assessments more than, say, 5% per year. That was a really common cap in these CC&Rs. And the legislature decided to eliminate or to override the caps that are written into the CC&Rs, only again for plat communities and miscellaneous communities that were governed by 6438, because otherwise HOAs can't do what they're required to do. In a world where we've recently had, I mean, a few years ago, inflation was like 7.5% or 8% in 1 year. If you have a cap on increases of 5% and inflation is almost double that, how do you continue to pay for insurance? And again, insurance is a whole topic on its own, and the cost of insurance has increased astronomically, well beyond what inflation has been doing. So the legislature recognized the impossibility of these two things existing at the same time, and wrote the bill to eliminate what your documents might say about caps on increases. I do want to remind everybody that this does not apply to condo associations. It only is true for communities that are governed by the HOA Act. And it means two things for virtually every single HOA Act community. Caps on increases are eliminated, and the budget ratification process that's dictated by 525 replaces whatever process your community had in place before. And it doesn't matter whether you voted on it or not. This is something that the legislature decided top down and imposed on all of us, regardless of whether your community voted to adopt it or not. There's a follow-up to the 525 question. What is the 5% cap? So the explanation of that is in many HOA CC&Rs, and in a handful of condo CC&Rs, but this is irrelevant to them because they don't get the benefit of this section of WUCIOA, there is written into the documents a restriction that the board cannot increase the assessments charged to the owners by more than 5% per year without the affirmative vote of a certain percentage of the ownership. And usually it's a vote that's like virtually impossible to get. So the effect of those caps on assessment increases was that you essentially could never raise the dues more than 5% per year. And again, the legislature sort of recognized the impossibility of HOAs continuing to meet their financial obligations while also being hamstrung by that cap on increases. And so that's why they decided to eliminate it. I don't want to spend too much more time on that topic. The question says, what about condos then? This is irrelevant to condos. If you're a condo and you have this cap on increases, it's still effective in your documents, because this part that erases or overrides those caps on increases only applies to communities governed by the HOA Act. So I don't know if you have anything to add, Lisa, but otherwise you can just jump into the next question.
I just wanted to say that the 525 provisions do apply to everyone.
Mm-hmm.
So make sure that, make sure your budget needs to follow the stuff set out.
So the budget ratification process applies to everybody, but the elimination of the caps on increases only applies for HOA Act communities.
And be happy that this has happened, because if your insurance rates have changed like the ones I'm seeing, you need more than a 5% jump in your assessments from year to year lately. Okay, next question. If the county is foreclosing on an owner for unpaid taxes, and we think there's a lot of equity in the property, can't we just record a lien and get in line to be paid out of what we think will be a lot of surplus funds? The short answer to this question is no. You cannot. The statute, which is 84.64.080 subsection 10, states that if there are excess funds, the excess funds must be refunded following payment of all recorded water and sewer district liens to the record owner of the property. Period. A period is my emphasis. Anybody else, mortgages, association liens, judgment liens, have no ability to apply for the surplus funds that may be there after a county tax lien only we're talking about. So this is a totally different rule than a normal surplus funds conversation we might be having with you if a foreclosure is happening by a mortgage, specifically non-judicial foreclosure. We might say, hey, yeah, you can wait around for record your lien. We'll see if there's money and we can apply for surplus funds. That's a totally different conversation. If the county is foreclosing on the property for unpaid property taxes, your lien has no right to apply for surplus funds. What that means is a couple of things. One, if you do nothing and you have a lien, you may have a right to pursue the individual owner personally for a judgment for the funds that are owed to the association, hoping that they have income to garnish or something like that. But the best case scenario, our recommendation often is to look and see whether the association wants to pay the taxes prior to the county recording the tax lien and add those taxes to the ledger for that delinquent owner. Because your lien will be wiped out if you don't. So it's definitely something to talk to your association counsel about. If you see, most times you'll see the notices posted by the county or receive a copy of the foreclosure complaint. If that comes to you, I'd say you do tend to have maybe 9 months to make that decision, but don't walk to your attorney's office and ask. They can help you contact the county, find out what the payoffs are, find out what the deadlines are. And oftentimes owners will end up paying their taxes before that comes up, but because their equity is, or they're not protected either by a tax lien. But that's definitely one of those things where you really want to get involved quickly. And that all this is confirmed by case law. The statute's very specific, but the case law is also confirms what we're saying here, that you have no right to surplus funds from a county tax sale. So make sure that you're on, if you see that coming, be on top of that. Usually it happens in King County anyway, about 4 years, 3 or 4 years of delinquent taxes. Other counties may differ. So like I said, certainly reach out to your attorney if you have any questions on that. Anything I missed there, Valerie?
No, I just put the case name in the chat in case anybody was interested in looking it up. And the case is really interesting because that one is actually a sewer tax lien that wiped out all the other creditors' liens. So we often think of county tax liens as being just for property taxes, and those are, $3,000, $4,000, $5,000 a year maybe. And so it seems less weird, I guess, that a lien of that magnitude could wipe out all of the other creditor liens against the property. But in the Seven Sales LLC versus Otterbein case, and I don't know if I'm saying the Otterbein name correctly, right, it was a sewer tax lien. So the dollar amounts were much less than we would have been looking at if it had been property taxes. And even in that case, the court held that only the record owner of the property could apply to the court for payment from the surplus funds. So if you've got a property in your community where they owe you money and they're past due on their taxes to the point where the county has started its tax lien foreclosure proceedings, consult with your attorney quickly to see what your options might be. All right, our next question is this. In our bylaws and the RCWs, there is language about if you do your HOA meeting via Zoom only, for example, there's language about a central conference connection that must be available as well. Does a dial-in number qualify for this, or do we have to have someone in a room giving other HOA members access to the Zoom meeting? It seems counterproductive if we want to just do a Zoom only meeting, and we'd rather not have to set up our clubhouse as well when we do Zoom only. So The short answer to this question, at least with respect to the statutory requirement, is that as long as you have a non-Zoom option for people to call in using a regular phone, then you're fine. The question about what your bylaws or your governing documents say or don't say is too specific for the context of this Zoom. So I don't know what your bylaws say, but it's not that I don't care, but I don't want you to tell me because I can't comment on that in the context of the Zoom. But the statutes do allow for meetings to be held by Zoom or other video conferencing software as long as there is an ability for an owner to call in. So for example, if you have an owner in your community that does not have a smartphone and they don't have a computer, you still have to provide a way for them to call into the meeting. Most Zoom, as a great example, most of these video conferencing softwares automatically have the ability for somebody to call in and join audio only, to be able to follow along with the meeting using a telephone. If the software that you're using doesn't have that ability, or if you have to tinker with settings in order to make that an option, then you need to do what you have to do in order to provide that option. So the language in all of the statutes right now says, except as otherwise restricted by the declaration, bylaws, or articles of incorporation, meetings of unit owners may be conducted by telephonic, video, or other conferencing process if A, the meeting notice states the conferencing process to be used and provides information explaining how owners can participate in the conference directly or by meeting at a central location or conference connection. So the use of or is really important there. And B, the second requirement is the process provides all unit owners the opportunity to hear or perceive the discussion and to comment. So one thing I would like to point out, for example, is that Zoom has different functions. You can have a Zoom meeting like what we're doing now, or you can use a Zoom webinar function, which is broadcast only. That does not qualify. If there's not an opportunity for the owners to both hear and comment, then whatever process you're using does not qualify under the statute. So if you look up 6432, 6434, 6438, or 6490, depending on which of those statutes governs your community, and the word meetings, if you just Google that, it will take you to the section of your governing statute that pertains to meetings that has the language that I just covered. I will offer that there is a new version of WUCIOA that will take effect next month. And it actually goes even more specifically into the details here. It says a meeting of the unit owners is not required to be held at a physical location if the meeting is conducted by a means of communication that enables owners in different locations to communicate in real time to the same extent as if they were present physically in the same location, provided that such means of communication must also have an option for owners to communicate by telephone. And the declaration or organizational documents do not require that the owners meet at a physical location. So one thing I want to say is both the language that I read you before from the statutes as they exist now and the language in WUCIOA as it's going to be amended, they say except as otherwise provided in your governing documents. So if your governing documents require a physical meeting, you need to consult with your association attorney to determine whether you need to amend that in order to allow your community to do Zoom only or virtual only meetings. And I think one of the things that we've talked about a lot in our office when we're looking at the way WUCIOA is going to change next month, we think the intent is, I think that there was maybe some confusion within the legislature because all the changes to WUCIOA this year were adopted as part of the same bill that's making WUCIOA applicable to everybody in 2028. And so some of the ways in which the legislature tinkered with WUCIOA, the changes that are going into effect this year, I'm not sure everybody fully realized that it was going to create a separate set of rules for certain things for WUCIOA communities now. And for 2 years now, we've had uniformity, for example, on the subsections of our statutes that have to do with voting, that have to do with meetings, that have to do with notices. And so now there's some changes happening with WUCIOA this year, but those changes are not going to be applicable to everybody else until all of WUCIOA is applicable to everybody else in 2028. So I think that's maybe one of those things where it's like unintended consequences, right? But more to the point, I think what the legislature is doing as it tinkers with WUCIOA is very clear indication of their legislative intent for how they want community associations to do business and to conduct themselves in Washington state. And so whenever you find yourself sort of asking the question of how do I comply? What does the legislature want? I think if we go back to the ways that they continue to change and fine tune and revise WUCIOA as a clear indicator of legislative intent, that's a pretty darn safe argument, in my opinion. So all of that is to say, you don't have to do both as long as you've got a call-in number. I can't answer that question for any specific community without knowing what your governing documents say. So if you need this answer for your community, the person who submitted the question, you need to consult with your association attorney. And I think that covers it unless you want to add anything, Lisa.
Nope, I think that covers it.
Okay.
So the next question is there a minimum number of board meetings required by law? Once every quarter? The short answer to this question is no, but there are some big caveats there. The first thing is if you're a WUCIOA community, you're required to have 4 meetings per year during the declarant control, and then you have to see whatever your governing documents say and you know what your board determines. The second thing is look at your governing documents because they may have specific requirements. So make sure that when you're setting your schedules for the year, that you are complying with whatever your bylaws or CC&Rs state is your required board meeting schedule. And then also keep in mind that your job as a board member is to take care of your community. So you have a duty of care to the association, and you should make sure that you're meeting often enough to act in the best interest of those members of your community, and make sure you're responding to concerns and the business of the community as needed. As Valerie mentioned before, because of electronic Zoom type meetings, it's a lot easier to hold meetings now, and I think you get a lot more participation. So that if you have a lot more meetings than 4 per year, once every quarter, that is easier to do. And also keep in mind that, as Valerie also mentioned, in 2028, that WUCIOA is applying to everyone. And right now, if you're not a WUCIOA community, you may be able to do some types of decisions by email that under WUCIOA you may not be able to do. So WUCIOA only allows you to do they call ministerial decisions outside of a meeting or by email or other methods. So keep in mind that you're going to have to hold meetings to have decisions on most topics that are not, as I said, purely ministerial, and that's a whole other conversation of what that actually means. But generally speaking, a meeting is going to be the gold standard to make decisions on board business or association business. Anything I missed there, Valerie?
I mean, it's not, you didn't miss anything. I think this is going to come as no surprise to people who have participated in this Q&A for a while, that I really wish most of my clients would meet more often. I have clients that meet once a quarter. I have clients that only just meet whenever the board feels like it. And sometimes I have to wait months to get a board decision, for example, on if an owner has submitted a settlement offer on their account, for example. And I have to wait months and months and months, to the point where I feel like I'm riding the line of perhaps not complying with my ethical responsibilities as an attorney and not getting a response to that owner or another party in dispute with the association because of the board's failure to act. And I have absolutely sent emails to clients saying that I think that you are failing in your duty of care to the association as a board member by failing to make a decision on this thing that I've been asking you to make a decision on. And I've also fired clients, not too many times before, but if I'm waiting 5-6 months, and meanwhile this file's open, I'm continuing to bill the association, they presumably want to be able to collect that money from the delinquent owner in question on that particular file. At a certain point, I cannot support that file staying open or continuing to work with that client when the board is just refusing to take action. So those are really strong words. I think most of our boards are doing absolutely the best that they can. And I recognize that you guys are all unpaid volunteers, most of whom have full-time jobs. And you're doing this work out of the goodness of your heart and out of a desire to benefit your community. So by no means am I painting boards in general with that same paintbrush, but I think that it would make most of your attorneys happy if you met more frequently. Also, if you met once a month, your meetings would be shorter.
I was
Sometimes
just going to say that.
sometimes boards are like, we don't want to meet more often. Our board meetings last for 3 hours. Well, if you met every 4 weeks or every month, they probably wouldn't be 4 hours long. So that's something to keep in mind. And then again, I want to beat that drum. In 2028, you are all going to be subject to WUCIOA. WUCIOA does not allow you to make unanimous decisions in writing outside of board meetings. Pretty much, period, end of story. You can make ministerial or like minor administrative decisions outside of board meetings, and you can maybe make decisions that are essentially affirming decisions you have previously made in a board meeting, but that's it. So you won't be able to vote on foreclosures. You won't be able to vote on settlement offers. You won't be able to vote on signing a contract outside of your board meetings. So I think everybody should start practicing now and get used to more frequent board meetings and dealing with these things in real-time board meetings, because come 2028, you're not going to have a choice. So that's, sorry, soapbox, I will be done. I'm going to move on to our next question. How hard is it for an HOA to sell a bunch of small pieces of the common elements to lot owners? And does that ever backfire? The short answer is it's hard, and yes, sometimes it backfires. It's complicated. It requires the vote of a specific percentage of the ownership of your community. And you have to look at your governing documents to see, sometimes there are specific requirements, but also it almost always is going to require a revision to the plat maps or the survey map and plans, which, by the way, is not cheap. You probably need the survey and the legal description of every parcel to be modified to reflect the change. And the specifics of exactly what steps you have to take and also what percentages of ownership you have to get to approve these kinds of changes vary. But at a minimum, it's 67%. And in some communities, it could be as high as 90%. Some declarations will say that it's 100% if you want to change the nature of a common element into a limited common element or a part of a lot. And yes, it can backfire. We actually discussed this topic in a recent Q&A within the last 3 months for sure. I think maybe more like 6 or 7 weeks at the most. So I don't want to go into that again because this is a very specific question that I think is not super broadly helpful, but you can check our YouTube channel. Every video has, if you expand the description, has a list of the topics that we covered. And so you can check our YouTube channel and look at the videos for the last couple of months and find the one where we discussed this to hear some of the questions that we would raise with a client considering taking this kind of step. Did you have anything to add to that, Lisa?
Nope, I think that covers it.
Okay.
Next question is, do affidavits asserting that at least one condominium unit resident is 55 years of age or older have to be notarized? What information is required on that affidavit? So HOPA, which is the Housing for Older Persons Act, requires that every 2 years, an association has to re-verify the information that is generated by their original survey to make sure they're qualified for the 55 and over exemption. It requires on its face that the following can be used for proof of age. So a driver's license, a birth certificate, a passport, immigration card, military ID, or another government document that shows date of birth. Or they could, or an affidavit, something that certifies that's signed by the person in the household that's 18, that they're 18 or older. An affidavit in Washington State doesn't need to be notarized. It can be a declaration, so it can be sworn in penalty of perjury, but this particular document doesn't need to be signed under oath. You're not required to get copies of other documents that you've already received from the owners or from the occupants of that unit. So if you just have to confirm that those people are still there and they continue to occupy the unit, the ones who previously submitted the information. So I'm not sure if there's anything else that's needed, but or what specific type of affidavit you're talking about, but I assume it's the affidavit mentioned as proof of age of the person residing in the unit, where you could require other information if you haven't already received it. Anything I missed there, Valerie?
Nope, I think you covered it. All right. So the next question is related to insurance, and it's written in a way that's really confusing. So we're going to do our best to answer what we think the question is. And if you want to rewrite the question and submit it again for a future week, you're welcome to do that. So the question that we received says the following: if an HOA master policy insurance policy has a $25,000 deductible, the claim is $50,000 less the deductible, and the unit owner's HO6 insurance, which includes coverage for the deductible, can the insurance company refuse to pay the deductible? So I'm not really sure. Again, I think the question is written in a way that's confusing to me, but I think that it might be the situation is this. There's a $50,000 loss. The HOA's master policy has a $25,000 deductible. And the question is, does the homeowner's insurance policy refuse to pay the deductible, or is this the master association that's refusing to pay? You know, so I'm not really sure. Number one, I'm not sure what the question is, but number two, these types of questions are generally pretty specific, and what they require is not just a review of the association's insurance policy, but of the owner's HO6 policy. So in no scenario is the association's own insurance policy going to pay the deductible. That's the whole point of a deductible, is that you have to pay the first $25,000, and then only once the loss exceeds that cost will the policy kick in to pay any difference. And whether the owner's policy has to pay the $25,000 deductible depends on the contract language of the owner's policy. But I think it's important to note that in almost all cases, whether the owner's insurance policy will pay the deductible is completely irrelevant to whether the association has the authority to assess the deductible to the unit owner. The contract between the association and the unit owner is the declaration. If the declaration has been drafted or amended to provide for assessing the deductible to the unit owner, then you can assess the deductible to the unit owner. Whether their insurance will pay it for them is a whole separate question that's governed by the contract between the unit owner and their insurance company, which is the policy, right? I will offer a couple of pointers. Some governing documents require that you provide owners with notice and an opportunity to be heard before you assess the deductible to their unit. And beginning on June 6th, WUCIOA is now going to require that you give notice and an opportunity to be heard before the deductible can be assessed to the unit. And so again, WUCIOA is going to apply to everybody in a few years as a matter of best practices. Not only should you be reviewing what your documents require as far as notice and an opportunity to be heard, but you should also plan for that change, which is coming down the road for everybody. Another change to WUCIOA that is happening this year is that you can't assess a cost for failure to maintain a component unless your association has published standards for maintenance of that component. And the standards have to make it clear that if owners fail to do the thing you're telling them that they have to do, they could be responsible for those costs. So let's take a water heater as an example. It's a common component that associations want people to take care of and replace. Under the changes to WUCIOA, even if your declaration says that you have the ability to pass on the deductible to the responsible unit, unless you have published standards either in your a declaration amendment or in, like, say, a high risk component policy that says owners are required to replace the water heater every 10 years and failure to comply with these standards may result in the association's deductible being assessed to your unit. If you don't have a policy that says that, you are not going to, under WUCIOA, be able to assess that cost to your unit owner. So you should keep that in mind. Consult with your association attorney. The only other thing that I'll say is there are 5 or 6 different sections of the declaration that we look at when a client tells us XYZ thing happened, who has to pay for what. And it's not just the insurance sections. So this is a relatively complex analysis that requires us to look at many different sections of your declaration. And it is very often the case that, for example, a collection matter will come to us 2 or 3 years after $10,000, $15,000, $20,000 has been assessed to the owner's unit, only for us to review the declaration and tell the client, oops, you do not have the authority to assess that to the unit. Or maybe you did have the authority, but your process was flawed, and I'm not sure you can go back this far after the fact and fix the process. So when you're thinking about assessing these costs to your unit owners, please consult with your association attorney before you do so that you can correct your process and fully understand what your rights are before you try to make these assessments. Lisa, did you have anything to add?
No, I was just going to kind of reiterate your point about the requiring, it's hard to say together, the notice and opportunity to be heard, especially from a collections standpoint. as Valerie said, when we get something, it says this person was assessed a deductible, but we never told them about it. That's a red flag, of course. How is a person supposed to know they need to pay something? But I think just as a best practice tip, why not send notice to your owner, give them an opportunity to comment or to be heard on that, even if you're not subject to WUCIOA and you're not required to. It makes sense to at least put your owner on notice that that's what's happening, because we'll certainly want you to have done that if it comes to collections. Okay, next question. Our association has 20 plus years of documents in a storage unit that now costs over $200 a month. We'd like to clean house and digitize and could use some guidelines regarding which documents need to be kept and for how long. I've read lots of advice on what should be in board meeting minutes, but I want to confirm how committee reports should be treated. We have an active landscape committee, for example. Would we just record their recommendations and how the board votes? Sometimes there's information in there that would be helpful for owners to know about project or irrigation scheduling, for example. The short answer is that, well, number one, you can certainly digitize anything you want and everything you want. And in fact, we encourage that. So whether we're talking about 20 years worth of stuff or shorter amounts of time, digitizing makes much more sense and is much more cost effective. But you need to look to the statute that governs you and take a really cautious approach about things like committee records, board records, et cetera. We've talked at length about all the records statutes that were recently changed. So you can certainly just Google RCW 6438 and the word records or whatever governing statute you are under.
I just put them all in the chat.
Oh, thank you. And that will tell you, they're all pretty similar, but again, as we discussed, WUCIOA threw a little wrinkle in and changed some of the things for their most recent iteration. Just why not, to make things a little more confusing. The short answer is you don't necessarily have to keep 20 years worth of all of records. In many cases, it's 7 years, except that board meeting minutes are one of those things that are permanent records. So if you have board meeting minutes going back 20 years, those should all be digitized if that is what you're planning to do, or at least kept in some fashion. It is much simpler, just as a plug from my end, to have things digitally saved. And as I mentioned, probably considerably cheaper. There are a lot of, you can look around. I know on the CAI message board has been discussed a lot what kinds of digital, banks basically people are using, whether it's Google or some other company. There are affordable options that are certainly less than $200 a month for maintaining your records. So make sure you're looking there. Things like you asked about landscaping records, 6490, 495, subsection 1J says materials relied upon by the board or any committee to approve or deny requests for design or architectural approval need to be kept for a period of 7 years after a decision is made. For example, meetings relied upon by the board concerning decisions to enforce the governing documents should be kept for 7 years. So it's likely to be the answer is 7 years, but you're going to want to look and see what specific documents you're talking about. And again, if these are board meeting minutes, keep them all. Did I miss anything, Valerie, on that?
No, and I just put into the chat the statute that authorizes essentially anytime that you have to keep a record, you can keep an electronic record of that thing, and that satisfies your obligation to keep the record. So this is a relatively new statute within the last 3 or 4 years, I think, that basically says if you have to keep a record, a digital copy of the record is fine as long as it's a complete and reliable copy of the original.
And it's pretty easy to digitize things. Contact, there are services that will do that for you. You may have a law firm or somebody else in your life who you may be able to talk to about utilizing their equipment for digitizing documents. So, keep that in mind.
We have clients who come into our office with, I think we had one with 30 boxes, banker's boxes worth of stuff. And there's 8 boxes in our office right now for another client. We have one of those high-speed scanners. And if you're a client of ours, you're welcome to contact us to come in and use one of our scanners to digitize your records if that's helpful to you. But we do have to limit that offer to clients. So I'm going to move on to our next question so we can hopefully try to get through all of them, if not the ones in the chat today. This one says, though we are not a WUCIOA community, we understand that RCW 6490-095, which is about the election of pre-existing communities, is one of the provisions that does apply to us. What is the change to 095 that is expected in 2024? There's no substantive change. This is the section of WUCIOA that applies to how a community, a pre-existing community, can opt into WUCIOA with a easier, lower percentage required amendment process. The only change to this subsection that's happening this year is the addition of the language as recodified by the act, or this act, after a few of the sentences in the section. So basically, there's no actual substantive change to this subsection. So that's all I have on that one.
Okay. Next question. If a special meeting is held to vote on a bylaw amendment and the vote is taken not at the meeting, but after the meeting with an electronic voting app, is this considered voting at a meeting where there's 67% approval required? Or is it a vote by written consent where you'd have to have a majority of the total voting power required? Also, let's see, the meeting and the vote both met the quorum requirement and proxies were used in some cases for the electronic vote. This is a really specific question that is a little bit complicated to answer for me. But in general, owners can vote in one of three ways. They can vote in person at a meeting via ballot or absentee ballot or by proxy. And you can look up your statute to see what is governing your community. But note that the voting provisions of WUCIOA are revised effective, like a lot of things, June 6th, 2024. So there's a new electronic voting section that's added, which says you can't require owners to vote electronically, which is a big deal, in my opinion. So it means you have to send a paper ballot to an owner who does not consent to vote electronically. Casting a vote, so if you send out the notice of electronic voting and the person casts it, that is considered consent to vote electronically. So keep that in mind. And if a person does vote by paper, you have to count that ballot. How you count that is a different conversation, but you do need to count that ballot. Another thing I wanted to note is that a new WUCIOA requirement also says that for any election or declaration voting, you have to use secret ballots and you cannot reveal how people voted under the new record section of WUCIOA. So that's a pretty big change, and that's a pretty big deal. Those kinds of elections have to be made secret ballot, and you cannot reveal who voted what way for either of those things under WUCIOA. We're running out of time. We have a lot of other things. Anything I should make sure I mention under this one, Valerie?
No, I don't think so. I think, the short version, or the TLDR, as I say, is that we can't answer your question for your particular vote in your community. All we can talk about is sort of generalities when it comes to voting. If you Google your governing statute and the word voting, you can read through the voting section that's in each of the governing statutes, and it talks about things like absentee ballots, proxies, rules about all of those things, and how you have to conduct votes within your community. And if you're still in doubt, then you should consult with your association attorney. Our next question, which is the last one that was submitted in advance, is thankfully a short one. If an HOA sent out a first delinquency notice with a late fee, but they did not include the statutory pre-foreclosure notice, what steps should they take to fix that after the fact? The HOA assessments are not high enough to ever reach $2,000, which is the foreclosure threshold, before the statute of limitations kicks in. You just send it. Send it the minute you realize you failed to send it with the first notice. That's the short answer. And this is true notwithstanding the fact that you will never reach the $2,000 minimum. You must send out the statutory pre-foreclosure notice of delinquency, either with the first written notice to the owner that their account is delinquent, or as soon as you realize that you failed to include it in that first notice. It is a statutory requirement, even if you know you're never going to foreclose, whether because of the circumstances you mentioned in the question or because your board is anti-foreclosure, maybe, whatever. Even if you know you're never going to foreclose, you still have to comply with the statute and send it out. And the reason behind this is the notice contains foreclosure prevention resources that the legislature wanted to get into the hands of these owners as soon as possible. And so even if they're not going to use those resources, even if you don't care that they're not paying, even if you're never going to foreclose, you got to get that in their hands. as soon as possible. The other thing to remember is even if an owner has opted in to electronic notice, the pre-foreclosure notices of delinquency have to be sent by mail, both to their address within the community, even if they don't live there, and to their offsite mailing address if they live elsewhere. So that's a unique requirement that's specific to this foreclosure NOD that we're talking about. And that took us right up to 11 o'clock. So I apologize that we didn't get to many of the questions from the chat. Thank you all so much for joining us. And we'll use those to be seeds for our list for next week. So see you guys then. Bye, everybody.